Good morning. Welcome to the Office of Tax Appeals. We are ready to begin with the appeal of Franklin J. Dulian Exemption Trust. OTA case number is 221111754797. This hearing is live streamed. Present today is the stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speak one at a time and does not speak over each other. Also, speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is an independent and neutral agency. It is not a tax court. All three judges are co-equal decision makers, and we can ask questions at any time. I'd like to offer a few reminders to help the process run as smoothly as possible. Please ensure your microphone is not muted when you speak. Otherwise, you will not be picked up on the live stream. And as a reminder, these proceedings are being broadcast live, and anything said today and any information shared today is publicly viewable on the live stream. With that said, are there any questions before we go on the record? Mr. McLeod, do you have any questions?
There we go. For some reason, I wasn't able to unmute. No, I don't have any questions. I just want to make for the record, nobody told me this was at 9:30. I looked at your minute order from our conference and it just simply said it's in the AM. And I assumed it was the same time as the conference. So I understood this was at 10:30, not 9:30.
Okay, I understand, but we're all here now, so we'll just move on from the delay. All right, Ms. Alonso, are you ready to open the record? We are opening the record in the appeal of Franklin J. Dulian Exemption Trust. The OTA case number is 2211117754. This matter is being held before the Office of Tax Appeals. Today is December 18th, 2024, and the time is approximately 10 a.m. This hearing is being convened electronically. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Keith Long, and I will be the lead administrative law judge. Judge Natasha Ralston and Judge Asaf Kletter are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. As a reminder, the Office of Tax Appeals is not a tax court. It is an independent appeals body. The panel does not engage in ex parte communications with either party. OTA will issue an opinion based on the party's arguments, the admitted evidence, and the relevant law. For the record, will the parties please state their names and who they represent, starting with the representatives for Franchise Tax Board.
Good morning. My name is Arthi Ramalingam, and I represent the Franchise Tax Board.
Good morning. This is Brad Catino, also representing Franchise Tax Board.
Thank you. And for the appellant?
Yes, Stephen McLeod, appearing on behalf of the Franklin J. Dulian Exemption Trust. I'm the actual trustee.
Thank you. There are 2 issues in this appeal. First, whether appellant has established reasonable cause for the late filing of its return for the 2019 tax year. And second, whether interest abatement is warranted. There are no witnesses for this appeal. The exhibits for this appeal consist of FTB exhibits A through F. At the pre-hearing conference, there were no objections to these exhibits. Can appellant please confirm that there are no objections?
I have no objections to the exhibits.
Thank you. After the pre-hearing conference, appellant timely provided an exhibit index identifying exhibits 1 through 8, including 1, declaration of Tara Torbati, 2, reasonable cause memorandum, 3, request for appeal, 4, income tax due notice, 5, bill of rights and penalty information, 6, appellant reply brief dated 6/21/23, 7, appellant reply brief dated September 14th, 2023, and 8, all exhibits designated by the Franchise Tax Board, exhibits A through F. Mr. McLeod, did I summarize those exhibits correctly?
You did.
And Franchise Tax Board, do you have any objections to those exhibits?
We do not have any objections. Thank you.
Thank you. Franchise Tax Board exhibits A through F and appellant exhibits 1 through 8 are admitted into evidence. Today's hearing is expected to take approximately 45 minutes. Appellant requested 20 minutes to make his presentation. Mr. McLeod, you may begin when ready.
Yes, to the board, to the administrative law judges, let me tell you that this was a quite difficult trust that we had because there was an issue about capital gains tax, and initially, as indicated in the exhibits of both the FTB and myself, there was some confusion on the part of the account concerning the capital gains treatment. But that isn't the primary reason why this was delayed. And I'm asking you to receive all of my exhibits. I guess you have. And I don't want to be redundant with what's contained therein. But my principal concern was that the primary reason why the account didn't get this done was the issue of the COVID, which we're all well aware of. And I was thinking on my way in today that very likely, I assume you're somewhere in Sacramento, but very likely you probably drove by a number of closed or shuttered businesses and restaurants that closed because of the pandemic. I know that's certainly true here in Los Angeles, where we saw terrible financial dislocation because of COVID. And in a sense, this case is similar to those businesses. And one thing I wanted to take a look at was the governor's statement of emergency in California. And one of those provisions that the governor, our chief executive officer, said that we were to support consistent practices across California's state departments in coordination with the Office of Emergency Services shall provide updated and specific guidance related to preventing and mitigating COVID-19 to schools, employers, employees, first responders, and community care facilities by no later than March 10, 2020. This is dated March 4, 2020, and the governor didn't lift it until February of 2023. So by definition, all businesses were subject to this emergency declaration. And here you have the declaration of the accountant indicating that she was ill. And that was the predominant reason why the filing was late. And I think, just as a matter of comedy, that there's really no reason to hold the trust as not in compliance with the reasonable cause and citing authorities of 40, 50 years ago. My goodness, the pandemic was a unique event that has not occurred for 100 years. I'm thinking of the famous 1918 flu epidemic. So all California business, and this certainly must be things you're seeing regularly, we're under tremendous pressure. And our own governor indicated that you should consider that in making any decisions on behalf of whether the Franchise Tax Board was correct or not. And it just seems to me, under the circumstances here, that with Ms. Torbati's declaration, she asserts her right, which of course is her right, to not have to disclose her evidence. But I will tell you, I office in the building here with her, and she was out of her office for, it had to be about a year. And as such, with all of that, I think under those circumstances, it was reasonable cause. And I don't think that we should be subject to having to pay a penalty plus interest under those circumstances. I think it is uniquely due to the pandemic. And as such, I don't think that, and I did brief, incidentally, in the paperwork, the issue of reasonable cause. I think reasonable cause was here, but certainly in addition to the pandemic and what Governor Newsom did about, for what, 3 years or so, having us under a statement of emergency. I think all those taken together excuses this late filing, and there certainly wasn't any intent. And as such, I think that the trust should get returned the penalty and the interest. Of course, we're not talking about a huge sum of money, but it's more a thing of principle than anything else. And as such, I think that should be returned to the trust. And I just want to be sure that that you are receiving, your honors are receiving all our exhibits, which we would ask that you, I don't want to go over them. I could read them, but I don't want to take your time to do that. But I think in particular, that last exhibit, the reply brief of 9/14/23, I would ask that you look at that very carefully, because I think that's really the key argument that we're making here.
Okay, thank you. Yes, everyone on this panel has access to those exhibits, so we'll all take a look at that briefing. Does that conclude your presentation?
My opening, yes. I reserve the right to respond to the Franchise Tax Board, of course.
Yes. Okay. Well, before we move forward with Franchise Tax Board's presentation, I just want to follow up with my co-panelists. Do you have any questions, Judge Ralston?
Not at this time. Thank you.
Thank you. And Judge Clutter, do you have any questions?
This is Judge Clutter. I will hold any questions until after the parties finish their presentation. Thank you.
Thank you. Mr. McLeod, I did just have one question with respect to the CPA's illness. I know that she's asserting her right to not disclose medical history, and that's fine. Is there any evidence in the file that would indicate that she was sick during the extended due date time for filing a return of July 15th, 2020, or even October 15th, 2020?
Well, I don't have any evidence, but my recollection is, I mean, I could testify that she was not in her office in that period of time when those returns were due. I would go to her office periodically, and she was never there. She's literally just down the hall of my building here. And so I would go down, and she wasn't here. I was unaware that she was ill, though. I have to say that quite frankly. I just figured she was out visiting her clients and so on and so forth. So
Okay.
It would only be my understanding that she was ill during the period of time that the return was due.
Gotcha. Okay, thank you. That concludes my questions. Franchise Tax Board, I believe that you requested, let me just pull my notes up here again, going between screens, 10 minutes, and you may begin when ready.
Good morning. My name is Arthi Ramalingam. With me is my co-counsel, Brad Catino, and we represent the Franchise Tax Board in this matter. This case is about appellant not establishing reasonable cause to abate its delinquent filing penalty because the justifications provided do not rise to reasonable cause. Respondent imposed late filing penalties for the 2019 tax year because appellant filed a 2019 tax return in June of 2021. Appellant argues they are entitled to reasonable cause because their accountant was unable to file timely due to COVID-19, despite appellant providing their accountant with the necessary documents in advance. Although it is unfortunate, an accountant with COVID-19 does not qualify for reasonable cause. In United States v. Boyle, the U.S. Supreme Court held that a tax preparer's reliance on an agent, such as an accountant, to file a return by the due date is not reasonable cause. In the appeal of Belcher, the OTA panel held that to establish reasonable cause, the taxpayer must present proof that they were continuously prevented from filing a tax return. Although reliance on advice of an accountant on matters of complex tax law may constitute reasonable cause, the Supreme Court in Boyle held that reliance cannot be a substitute for compliance with an unambiguous statute. While appellant contends that its failure to timely file its 2019 tax return is due to external factors, including the health of its accountant, He has not provided any evidence of these circumstances. The fact that appellant provided its tax documents to its accountant prior to the filing deadline does not by itself constitute reasonable cause. Further, appellant has not provided any evidence regarding the health of their accountant. Appellant has not provided the dates of its accountant's illnesses, the dates appellant became aware of the accountant's illness, or what efforts, if any, appellant took to find another accountant to timely prepare and file its return. Furthermore, appellant did not file its return until approximately 1 year after the due date. Even if the accountant's illness extended throughout this period, we would expect an ordinarily intelligent and prudent business person to seek out another accountant or make other arrangements to timely file its return soon after discovering its accountant was unavailable and that its return would not be timely filed. Appellant has not established that it did so. Appellant also has not presented any evidence, any argument or evidence supporting the abatement of interest. In summary, appellant has not shown that it acted as an ordinarily intelligent and prudent business person would have acted under similar circumstances. Therefore, appellant has failed to establish reasonable cause for the late filing of its 2019 tax return. Accordingly, there are no grounds to abate the delinquent filing or interest in this case, and the Franchise Tax Board respectfully requests that it be sustained. I would be happy to address any questions you may have. Thank you.
Thank you. Judge Ralston, do you have any questions?
No questions. Thank you.
Thank you. Judge Kletter, do you have any questions?
No questions at this time. Thank you.
Thank you. Okay, I also don't have any questions. Mr. McLeod, you requested 10 minutes to respond to Franchise Tax Board.
Yes. First of all, I'm assuming counsel is, I guess I'm criticized for not being ordinarily intelligent, but I suppose that's probably the legal standard, and that's why she's using that verbiage. But I would say this, has anybody been around for the last 3-4 years? Council has not addressed at all that we were under this terrible situation with the pandemic, which has led to, some pretty difficult things that have occurred in the country in terms of politics and the social distortion caused by COVID, but most especially the disaster it was to the economy of not just California, but the entire country, the entire world. And in spite of this huge event that impacted this particular case, this modest little case, the Franchise Tax Board says nothing about that and goes back to, the argument about reasonable cause on cases of 40, 50 years ago, not in the environment that we were in as of March of 2020, when the governor, the chief financial officer of the state, made a determination we were under an emergency. And during that time of an emergency was when the delay was caused by the illness to the accountant. And I can only present when I'm able to present. And under those circumstances, to just ignore it and to say you weren't ordinarily, and again, I understand this is probably the legal standard, but you were not ordinarily intelligent. Well, my goodness gracious, the environment we went through, and I don't doubt there are probably a lot of appeals that come up with much of the same argument. And it just seems to me, since the governor did not take away that emergency declaration until 3 years later, that under these circumstances, it is reasonable cause, all that happened in this case. And with the backdrop that we were under this emergency declaration of the governor. So again, I would argue that we are entitled to get back the penalty as well as the interest for those reasons.
Okay, thank you. Before we conclude today's hearing, I just want to check with my co-panelists. Judge Ralston, do you have any questions before we conclude?
Yeah, just a question for Mr. McLeod. Do we know when the appellant found out about their CPA's illness in relation to the due date for the return?
It was sometime after the due date. My recollection, it was later after the return was due. I had provided all the materials and it was later, but I did not know at the time that the return was due. I found out about it later.
Thank you.
Thank you. And Judge Clutter, do you have any questions before we conclude?
This is Judge Clutter. I just have a follow-up question on the last question. So this is a question for Mr. McLeod. So, as the due date for that return was approaching and you were not hearing back from the accountant, what course of action did you take, if any?
Well, Your Honor, I addressed that in the attachment that is in both sets of documents. I contacted her. I made efforts to find out what was going on. As I indicate in that statement, I was quite concerned. And, I never got a clear statement from her until later when I found out that she was ill and had not, even though she had the materials, that she'd been unable to submit it because of her illness. So that's all I can tell you, Your Honor.
This is Judge Clutter. No further questions.
Thank you. All right. Well, then we are ready to conclude this hearing. This case is submitted on Wednesday, December 18th, 2024. The record is now closed. I want to thank everyone for joining us today. The ALJs will meet and decide your case later on, and we will send you a written opinion of our decision within 100 days from today. Today's hearing in the appeal of Franklin J. Dulian Exemption Trust is now adjourned. The